True freedom requires the rule of law and justice. But what is justice without respect for human rights? What are these rights? Do you know your right as a citizen of the Federal Republic of Nigeria? What are your obligations and responsibilities under the law? Join Kayode Aderemi Esquire on The Law and You on Rockcity 101.9 FM, Sundays 3 p.m. to 4 p.m.
All right. It's a beautiful and sunny, or should I say rainy? No, it rained much earlier and it rained yesterday. Well, it's a sunny afternoon here in Abeokuta, Shiro here. So it's a sunny one, and that is your darling station, Rockcity 101.9 FM. We're speaking live from Abeokuta, Ogun State, Nigeria. That's West Africa. I told you once you hear that song at about 3 p.m, Tamola, that is who knows tomorrow, then it's about time you listen to your program. I've always told us, and of course you can prove me right or true, that this program is really about you, where we get to dissect issues regarding law as have to do with you. I told us of a story of when my uncle came from the US, and then I opened his car door, and somewhere in the safe I saw a lot of tapes: criminal law, civil law, land law. Uncle, are you now studying law? He said no. He said as an American, it is the norm. An average American should know what the law is saying. I said, wow, that's beautiful. I said, even me studying law, I don't have tapes this much in my car like you do. So that taught me a lot of things. That's why he will tell you I know my rights. So even if someone is caught committing a crime red-handed, you know, you still hear I am things like I want to talk to my lawyer. I want to talk to my lawyer, really. And that's why you hear freeze. You know, we don't freeze here. You melt. When police catch you, you go melt. You don't go freeze. Respect to my police friends, actually. All right. So it's a program where you know you're right, like you're about to say. You get to, you know, ask questions. Why? Why so? Why so? And that's where revolution starts. You know, when you know exactly what your rights are. I'm a regular host on the program and presenter. I'm Kayode Aderemi. Well, today we have a guest in the house, a very vast and experienced guest. When the time comes, I'll tell you what his name is. He's going to be doing justice to today's topic. All right, we talked about Section 38 last week, and we had the concluding session. We talked about right to freedom of thought and religion, conscience, etc. We talked about your thoughts, your conscience, your religion, right to change religion, and the likes, many things. We talked about the exception to Section 10 of Nigeria Constitution says that the federal government or the state shall not adopt any religion as a state religion, you know. But then when you now fast forward to Section 30, Subsection 4, it says that if Subsection 2 says that no educational institution shall impose its religious inclinations, I'm paraphrasing, on the students of an educational facility, but where such facility is wholly maintained or wholly run by a particular religious organization, then they may impose their religious views on the students or pupils of that organization. That's what the law says. We talked about quite a lot of things, and we ended with the fact that secret societies are proscribed in Nigeria. So if you're listening to me and you belong to a secret cult, what you are doing is unlawful. No law permits what you are doing. And one day or the other, there will be a nemesis, kind of. The word secret means it can't be known to the public. All right, there's a lot to discuss today, and time wouldn't permit us to dwell too much on what we've discussed so far. If you could not, you can try to log on to our YouTube page on Rockcity. You can see our videos there. Today we have a guest in the house, like I said, and we shall be doing justice to the topic that has been tagged Termination and Reduction of Wages by Employers during COVID-19 or COVID-19, as others would like to say it. Yes, I think I should just go ahead to tell us who he is. His name is Ireoluwa Oguntunwase. I discovered that for those of us following our WhatsApp page, you know, feedback platform, many of them were just saying, we know him. And I said, am I bringing the governor to the studio today? He's a popular man. than thank God popular for the good reasons. He told me, when I said, he said, it's good to be good. I said, yeah, right. Okay, now, Ireoluwa Oguntunwase is a lawyer. He's a senior associate in Elvira Saleras, whatever that means. He's going to tell us. An associate, a commercial law firm in Victoria Island, Lagos. He's the founder of Labour Clinic Niger, an Instagram platform created to advise and enlighten employers and employees on sensitive labor issues. He's also a lecturer. Ireoluwa is also a lecturer and Chartered Institute of Personnel Management, CIPM, Ikeja chapter. You can see when you see quite intimidating profile, you get to shiver. Well, that's Ireoluwa for you. Quite an unassuming man, very, very humble, I must tell you. And today, of course, I've been following him for quite some time. He has penchant for labor matters. So if you are listening to me, you are either an employer or an employee. So yeah, it's possible to even employ yourself, by the way. So please call your friends, tell them to tune in now to Rockcity 101.9 FM. Your program is just about to start, and very shortly he's going to have the table. Like I said, there's a lot to discuss. Please get your pen and papers ready, so that when it's about 3:30 p.m., we turn the tables and we give you the mic to ask your questions and share your thoughts on today's program. Please, I wish you can clap here. Welcome with me, Ireoluwa Oguntunwase. Me, I will clap over. All right, can I have you closer, please?
Thanks so much, Kayode. I really, really appreciate you. I really appreciate that introduction. Thanks so much. I think this particular topic is necessary because of what is going on right now. And it is no longer news that we're operating at a very difficult period because of the pandemic. And again, because of the pandemic, a lot of things are changing, including the world of work. But we need to understand something. The fact that there is a pandemic, does it mean that the law has changed? No. The fact that there is a pandemic, does it mean someone can go ahead and just trample or exercise the law in breach? No. So to that extent, I think it's very necessary for us to now understand how you can safely navigate your way with respect to when it comes to termination and when it comes to reduction of wages, because whether we like it or not, the implication of this pandemic has actually reduced the revenues of employer. And of course, if that fact is correct, which I know it is, then the implication of it is to cause termination, cause the employers to terminate. And if the employers don't want to terminate, they may think that the appropriate thing for them to do is to reduce the wages. But again, in employers going ahead to either terminate or reduce wages, are there laws that regulate it? Are there laws that govern this? Because we've received a lot of phone calls, a lot of comments from people saying that I was collecting XYZ salary and my employer just suddenly woke up and said because of COVID-19, I'm now to be collecting a very reduced salary. So in brief, we'll just be taking ourselves through this to examine the legitimacy and the position of the law regarding this, because a lot of people may be ignorant about their rights particularly when it comes to labor and employment matters. So I will just run through termination and reduction of wages as a result of during COVID-19, how employers can do it in order not to run foul of the law, because with termination with COVID-19 comes litigation, and if termination and COVID-19 will lead to litigation, if it is not properly done, then I think it's necessary for employers to avail themselves of the position of the law on how this can be done, so that they don't open themselves to litigation. Because if they open themselves to litigation, then they will need to pay lawyers, and again, the potential liabilities may also lie against them. So briefly, let's talk about termination. What is termination? Termination briefly means coming to an end of a contract of employment. You put to an end the contract of employment. That's what termination means. And there are several ways a contract of employment can be terminated. You can terminate by notice, you can terminate by resignation, you can terminate by breach. Termination can also be by death. Termination can be by dismissal. Now, having mentioned and having stated the types of termination, what is reduction of wages? Reduction of wages is just briefly put giving out a wage which is the reduced wage as against what is contained in the contract of employment. Now, let me say that the definition of wages is contained in Section 91 of the Labour Act, and wages is defined as remunerations or earnings designated or calculated, which must be expressed in a contract of employment and which is payable by the employer to the employee as a result of work done. That's the definition of wages in Section 91 of the Labour Act. Now, it is very necessary to say that wages must be included, the amount to be collected as wages must be included in the contract of employment. That is very important because wages is actually regarded as a consideration. The reason you are working, that is a wage, that is your wage. So wages must be included in the contract of employment, and if wages is included in the contract of employment and parties have signed it and the employer has gone ahead to keep paying that wage, is it now proper for the employer to just wake up one day and say, COVID-19, you are collecting XYZ, you now be collecting a reduced amount apart from XYZ? Now, let me say this. With respect to termination, if employers want to terminate as a result of COVID-19, we need to understand the laws generally that regulate termination. Now, as far as a common law employee is concerned, and let me say for common law employee, for example, a private employee, someone working for a private organization or for a private employer, as far as common law employee is concerned, the position of the law has always been that an employer can terminate for a good reason, for a bad reason, or for no reason at all. However, this position is no longer fashionable, and the reason the position is no longer fashionable is because we have what is called the Third Alteration Act now. And the Third Alteration Act is an amendment to the Constitution. And, by virtue of the Third Alteration Act, which is an amendment to the Constitution, then we now have some introductions. The Third Alteration Act actually brought about Section 254C, which is stated in the 1999 amended Constitution. And that Constitution, that particular amendment, now gave the National Industrial Courts, the power to be a superior court of record. Now, in addition to that, that particular provision also gives the National Industrial Court the powers to apply international best practice and also conventions that have been ratified. Now, the implication of that provision is this. The implication of the provision is that for conventions that have been ratified, or for conventions that have not been ratified but are seen as international best practice, then that convention can be used or applied by National Industrial Court in deciding matters. Now, I said earlier, that the position has always been that for common law employee, you can terminate for a good reason, for a bad reason, or for no reason at all. But now, we have the Termination Convention of 1982. Now, that convention is the 158th convention of the ILO, and Article 4 of that convention actually now says that if an employer wants to terminate, an employer must give a reason, and that reason must be premised either on good conduct, performance, or operational requirements. Now, the question now comes, can an employer wake up because of COVID-19 and just serve the employee a termination letter? In view of the Convention 158 of 1982, which is an ILO convention, I think it is not proper for an employer to do that. Now, the provision is very clear. Reasons must be given, and that reason can either be premised on good conduct, performance, or operational requirement. So that means an employer cannot just wake up and terminate without not giving a reason. And the National Industrial Court has applied this provision in the case of Ebere Onyekachi Aloysius against Diamond Bank. Ebere Onyekachi Aloysius against Diamond Bank, where the National Industrial Court was very emphatic on the fact that it is no longer fashionable for an employer to terminate an employee's employment without not giving a reason. So that means that if employment is about to be terminated, a reason must be given. But again, we are also not ruling out the fact that there is usually a contract of employment, or there should be a contract of employment that regulates the relationship between employers and employees. Now, that contract of employment can contain the requisite notice that an employer should give in the event of termination. Please, it is very, very important that in terminating, the employer must comply with the requisite notice. It is also the case that the contract of employment can say that in lieu of that notice, then the employer, if he wants the termination to take effect immediately, must pay salary in lieu of notice. It is very important that the employer complies with this. Now, the implication of this is that without prejudice to COVID-19, an employer cannot wake up and tell the employees that stop coming to work without not following the provisions of the contract of employment. Now, we've seen several cases whereby employers will even say stop coming to work orally without even not giving a notice. All these are termination in breach, and the implication is if the employer decides to terminate in breach of the contract of employment or in breach of the international best practice, then the employer is open to liability. And the liability is usually called wrongful termination of employment. And where there is wrongful termination of employment, the National Industrial Court is never shy to award appropriate liability in that circumstance. But again, with respect to termination, suffice it to also consider this. How can an employer protect himself? Is it possible for an employer to say that because of COVID-19, I want to suspend this contract of employment? Yes, it is possible. Under what circumstances can this be done? There is something that is called a force majeure clause. What is a force majeure clause? A force majeure clause is usually a clause. It's usually a clause in every contract, but most times employers don't put it in a contract of employment, and it all boils down to the fact that there is no experience. They don't have the experience. They just go ahead and do copy and paste contract without not noting the necessary clauses. Now, what a force majeure clause does is that, subject to the agreement between the parties, it says that in the event performance of a contract is not possible, this is what is going to happen. Literally, the meaning of force majeure is act of God. What it means is act of God. What it means is a supervening occurrence that exculpates a particular party from liability in the event performance is no longer possible. So if you have a force majeure clause in a contract, you can say that if so event occurs, then this contract of employment can be suspended. If you have that and you've already envisaged that, then you have nothing to fear. But I can tell you that a lot of contract of employment don't even have a force majeure clause. So if a contract of employment does not have a force majeure clause, and the employer now wakes up and say that, okay, I'm not making any gain for now, and there is this pandemic, so let's see, you guys should go home and I'll recall you after 4 months. That is not possible. Because the implication of that is if an employer decides to do that and tell the employees to go home, even without an agreement, the implication of that is that the contract of employment is still subsisting. And if the contract of employment is still subsisting, one of the fundamental duties of an employer under Section 1 of the Labour Act is to pay wage. Like I said earlier, by reason of Section 91, wages can be defined as remunerations or earnings, designated or calculated, which an employer is supposed to pay to an employee at a specific period by reason of the employee working for the employer. So if the employer tells the employee to go home because of COVID-19, and that maybe he's going to call them back after 4 months or 5 months when situation turns better, the employee can sue the employer for this period that he did not work, for the period that he is at home, and can even collect the salary because the contract of employment was not terminated. And if a contract of employment is not terminated, it's still in subsistence, and parties are not exculpated from performing their rights and responsibility in that instance. Now, it's also suffice it to say that with respect to reduction of wages, Section 5 of the Labour Act regulates reduction of wages. And what does this section say? This section gives instances when wages can be deducted, or when wages can be deducted. And the instances the statutory instances when wages can be deducted is in the instance of pension. We all know that there is a Pension Reform Act, and the Pension Reform Act, by reason of Section 4 therein, gives the employer the right to deduct certain percentage, 8%, from the employee's salary, and also add his own 10% so that pension can be paid. This is statutory, and the law allows it. Now, again, we also need to understand the fact that wages can also be deducted to pay check-off dues. Now, check-off dues are dues that are removed from employee's salary and remitted to their relevant trade union. So that means that if an employee is a member of a trade union, then check-off dues can be deducted. But even at that, it should be noted that for check-off dues to be deducted, suffice it to say that the employee must consent in writing. So the employer cannot just say that I want to deduct check-off dues without the employee not consenting in writing. That to tell you that wages cannot just be deducted anyhow. Now, having said that, we need to understand the fact that the passage for the employer in the event the employer wants to reduce wage is very simple. The employer can come to an agreement with the employee, call them in for a meeting, explain the situation to them, and after that has been done and the employees agree, then a new agreement should be drafted. So that means that the employer that has been paying XYZ cannot just wake up and pay a reduced wage without an agreement substantiating the reduced wage. That will be seen as a breach of the contract of employment, and the employee can sue the employer for the balance of the wages that is being deducted. So that is very, very important. So like I said, for reduction of wages, it is very important. Employers call the employee for a meeting. During COVID-19, employers that can no longer pay salary or that wants to pay a reduced salary, call them in for a meeting, have an agreement with them, do the minutes of that meeting, send it to the employees, let the employees sign it, and now further do what is called a wage reduction agreement. Now, the wage reduction agreement should now be made to supervene over the wage clause in the initial contract of employment. With that, if the employee signs the wage reduction agreement, then the employee can no longer come and be referring to the previous wage again, because he has already signed. He would have signed the subsequent contract, and the subsequent contract would have been either incorporated by reference into the main contract to an extent that no other contract will supersede over the subsequent contract. So if the employer can go ahead and do this, then I think there will be a safe passage for the employer with respect to wages. Now, for termination of employment, like I said, for employer to have a safe passage, it is very, very important for the employer to, in giving the letter of termination, the employer must ensure that the letter contains, in line with international best practice, complies with the procedure in the contract of employment, and the employer must also go ahead to include the reasons for termination in the contract of employment. And this is very, very important, because if the employer fails to include the reason or fails not to comply with the contract of employment, then it is very important to state that the employer may run foul of international best practice or the necessary contractual provision, and this can actually be detrimental to the interest of the employer. So I just want to enjoin employers that in as much as we're having bad times, in as much as this time is difficult, they shouldn't go ahead to do anything in breach. They should try as much as possible to comply with the relevant laws. And what I've discovered from my experience is that it will be difficult for employers to comply with relevant laws even when they do not know. And unfortunately, the human resource practitioners in organization have also not been able to avail themselves with the relevant laws to an extent that they will be able to advise the employers appropriately. So this is very, very important. Employers that wants to go ahead and terminate, or that wants to go ahead and reduce wage during this period must make sure that they consult a legal practitioner before they do this. In the absence of this, it is very likely, it is highly likely that an employer opens itself to liability, and with liability open itself to litigation, and with litigation comes liability, and with liability comes the employer folding up, because the National Industrial Court in assessing liability will not even look at whether the employer has the ability to pay. The National Industrial Court will assess liability based on the fact of the case. So that is it. Thank you.
You know, when I was reading the profile, I I had to clap at some point. For those that have been saying that they like the way I talk, they like the way I teach. So you have seen that I have a guy now. That's the voice of Ireoluwa Oguntunwase. And I was making notes, trying to carry along many of our listeners that call me after the program and say that program radio and all the likes. Well, let me try and mention just some of them, because as you can see, time is fast spent. By the way, anything pay me pay keep program good by law. But come and advertise on Rockcity, FM. Bring your programs along, your products, your services, and advertise. We can buy more time actually for you to know your rights. These things he has told us. I don't know how many years it took me to learn this in the university. Quite a long time. What he has just done for us, labor law. I think Mr. Wilson was okay. It was okay. That was taking us there back in school. He said, but when I started making money from me, I said it was a good one. But they can try, so dear Nibe, to Yakoko, Balai Kupo. He got also on Papa Gong. Quite a lot of things, like, because he you talked about termination. You to continue 2 months in the picking of the baby Oshemo. Mama give one termination in baby Oshemo. They are called for my shepe, Madame Shishemo. Okay, only or not happily, so pay came about Shishemo. You can notice, because you notice 2 months in the picking conflict with show up. I was a Bishemo, EKG breach. Because you got to breach 2 months in the pay. Boya, I want work on what any young bay, till she wants bay till they were long. I wanted to look at she. My one boy would be on fair work to go convey. Which she could live for, yet see noticing. And what's sort of about death? All of my Jakari Ogun, you cool, like Balon, you quite genosiwa. What if I didn't buy or just be bank pound on the bone like Balon? And to Bashalize, of course, automatically shed it off from here. He carry not to Sony dismissal. Oríṣiríṣi ọ̀nà ni wọ́n lè gbà láti dáhùn ní iṣẹ́ dúró àbí láti dáhùn dúró lẹ́nu iṣẹ́. Wọ́n tún sọ̀rọ̀ nípa reduction of wages tí wọ́n fẹ́ dín owó yẹn kù. Wọ́n ní kó give notice, in other words, kó sọ fún ẹni tó fẹ́ dín owó iṣẹ́ kù pé wá o à ń dín owó iṣẹ́ kù, wá ṣe máa débi ọ̀nà tó ń lè gbà láti ṣe. Wọ́n sọ̀rọ̀ nípa section 91 Labour Act tó sọ ìtumọ̀ wages. Wọ́n ní wages ni owó tí èèyàn ń gbà, tí owó yẹn iye owó yẹn ó dẹ̀ gbọ́dọ̀ wà nínú contract of employment, ìwé tó fi gbà ẹ́ síṣẹ́, or terms of service ó gbọ́dọ̀ wà níbẹ̀, oye tó gbọ́dọ̀ máa gbà àti iṣẹ́ tó ń ṣe. So oye tó ń gbà ó gbọ́dọ̀ wà nínú ìwé tó fi gbà ẹ́ síṣẹ́, because section 91 of Labour Act tí ó sọ nìyẹn. Wọ́n sọ̀rọ̀ nípa Arbitration Act, constitution wa wọ́n ti amend ẹ̀ lọ́pọ̀lọpọ̀ ìgbà. Ìkẹta section 254C ó sọ̀rọ̀ nípa National Industrial Court, ipò lágbára láti wo wípé àgbàníṣiṣẹ́ àbí báwo ni wọ́n ṣe ẹ̀wọ̀n níṣẹ́, ṣé ó lẹ́tọ̀ọ́ àbí kò lẹ́tọ̀ọ́ bó ṣe ẹ̀wọ̀n níṣẹ́. Ìkọ́ tí third Arbitration Act ń sọ̀rọ̀ nípa ní section 254C. So tẹ́lẹ̀tẹ́lẹ̀ ẹ máa ń gbé irú nǹkan báyìí lọ sí High Court, ṣùgbọ́n àgbà ti gbé òfin wá National Industrial Court ni ẹ máa ń gbé irú ẹ̀ lọ. Ọ̀rọ̀ tó sọ pọ̀ díẹ̀ kí n yán díẹ̀ níbẹ̀ sọ̀rọ̀ àtà lè gba ìpè àti ìbéèrè àwọn tí wọ́n fẹ́ pè wọlé, ìpè tẹ̀ tí ń wọlé gan bá ṣe sùúrù díẹ̀ ẹjọ́. Wọ́n dá fẹ́ dáhùn dúró lẹ́nu iṣẹ́, wọ́n ní a lè sanwó fẹ́ nìyẹn àbí kí a fi ìwé ṣọwọ́ sí. Sísanwó yẹn lápẹ́ ní payment in lieu of notice. Bóyá fẹ́ dá dúró ní oṣù tó ń bọ̀, a wá fún lówó oṣù yẹn tí dé o, a fún lówó oṣù yẹn. Ìkejì ká fi ìwé ṣọwọ́ sí. Ọ̀nà tí ẹ lè gbà púpọ̀, wọ́n ní agbanisíṣẹ́ tí ò bá tẹ̀lé àwọn ìlànà yìí pé ó ṣeé ṣe kó ń fojú ẹ̀ dófin tí òṣìṣẹ́ yẹn tó bá gbé lọ sí ilé ẹjọ́. Okay, wọ́n ní can employment be suspended because of COVID-19? Wọ́n ní yes, kí ló kọ́ tó pé ní force majeure. Force majeure yẹn out of God ni, bó ṣe kọ́ one school ni, but out of God má yẹ kí n lọ síbẹ̀ yẹn ṣáà mi kó máa rí àwọn ọlọ́run ètò pé ṣe mí ṣùgbọ́n God tọ́ mí bẹ́ẹ̀ kò mí ìgbé ọlọ́run ló ń ṣe gbogbo ẹ̀ náà ìjàmbá lè ṣẹlẹ̀ irú pandemic tó gba ayé kan yìí ó lè ṣẹlẹ̀ but tí ó bá máa ṣẹlẹ̀ kí ló máa fà á ọ̀nà wo ni agbanisẹ́ lè gbà láti má lùgbàdòfin ìkíní kó pe àpéjọpọ̀ àwọn tó bá ṣiṣẹ́ kó ṣe meeting kó dẹ̀ gba minute ìyẹn àkọsílẹ̀ àpéjọpọ̀ wọn yẹn ìpè wá ó dìgbà bàbá yẹn náà ṣáà rí pé owó wọlé o ó dàbí ọ́fíìsì tèmi ni ìgbà tí pínlẹ̀ àpapọ̀ ní ká má jáde mọ́ òye ni mo sán ọ́fíìsì pa tí mo di kọ́kọ́rọ́ mú nìkan náà mo ṣe máa bèrè pé ọ̀gá oṣù ti parí mo ní mo mọ̀ oṣù parí èmi náà mọ̀ mo ní kàlẹ́ndà ilé
ó lè gbé lọ sílé ẹjọ́ o
gbọ́dọ̀ ń gbà wá ó ní oṣù ti parí náà oṣù ti parí ìwọ wá bí iṣẹ́ àbí ṣé èmi ò ṣe táàsì kan ló sọ sálárì iṣẹ́ tó wọ èmi ò sọ sálárì yìí bọ̀ àjọ sọ́ṣà àjọ mọ̀ wọ́n mọ̀ pé wọ́n pé wá o àtẹ̀lé ṣe meeting gbà yẹn ọ̀gá Ireoluwa Oguntunwase sọ pé ká ṣe meeting corona wa ta wọn ni ká má bọ́ta báyìí ti bá ṣe meeting tá a bá gba minute
ẹ lè ṣe virtual meeting through Zoom
ẹni tó bá gbá ilé ọ́fíìsì nǹkan tí ò ní Zoom àwọn ìyá yẹn phone call mo pè wọ́n lórí fóònù náà mo sọ fún wọn kí bá bàbá yìí ẹ wọ̀rọ̀ yẹn pọ̀ jù bẹ́ẹ̀ yẹn lọ bọ́ jẹ́ kí n dalẹ̀ báyìí tó lásìkò ṣùgbọ́n ètò tún ṣe gbòógì sí mi bẹ́ẹ̀ ni ọ̀rọ̀ tó ń pè ní pension ìbéèrè àwọn tó ń fi ìbéèrè ránṣẹ́ ti wà ti pọ̀ gan lórí ọ̀rọ̀ pension yìí wọ́n ní 8% of salary ló yẹ kí wọ́n máa yọ ọ́nù salary ẹni yẹn then òṣìṣẹ́ á yọ 10% lápò ara ẹ̀ á fi sí á kó sí kọ́tọ́kùn ní pension scheme ọ̀rọ̀ pọ̀ ń bẹ̀ ṣùgbọ́n jẹ́ ń dalẹ̀ báyìí torí ìbéèrè ta nílé ni ó ti pé bíi àti fẹ́ pé 20 ìbọn 20 mo ṣà ń kọ́ wọ́n lẹ̀ èyí tábà lè gbà lé nínú ìbéèrè yẹn jọ ẹ dáríjì wá ready. Let's take a short break. When we come back, we'll take your questions.
True freedom requires the rule of law and justice. But what is justice without respect for human rights? What are these rights? Do you know your right as a citizen of the Federal Republic of Nigeria? What are your obligations and responsibilities under the law? Join Kayode Aderemi Esq on The Law and You on Rockcity 101.9 FM, Sundays 3 p.m. to 4 p.m.
Let's try and take the questions as fast as we can, sir. As fast as we can.
Okay. For Mr. Jonathan Ladering, if I get you correctly.
No, Ladering is the place.
Okay, from Mr. Jonathan from Ladering.
Yeah.
Sorry. Yes. He actually wants to know the reason he's not paid his entitlement. And let me say something. When it comes to contract of employment, when it comes to determining whether you're entitled to anything or not, is subject to the contract. Now, there is a principle that is called the meeting of minds, consensus ad idem. Now, that principle states that if anything is contained in a contract of employment, of course, the principle also suffices for other form of contract. If anything is contained in any contract and parties have signed it, that means their minds have met on all the terms and obligations in the contract. So it is it's going to be a breach for a party to now say that he's not doing something as contained in the contract. So what I'm going to say is you need to look at the contract of employment and you need to examine whether this entitlement that you think you should have been paid, they are all contained in the contract of employment. And for Mr. Anyobode from Ijeja, yes, you said you work in an insurance company and you gave 2 weeks notice and they didn't pay you anything. Now the question is, the fact that you give a notice doesn't mean that you will be paid. Everything is subject to the contract. Now you need to look at the contract of employment and you even need to ask yourself, did you even give the right notice? Because one thing that people, employees don't understand is that if when they want to resign, the notice period or the termination clause can say in the event of resignation, you give 1 month notice or you pay 1 month salary in lieu of notice. If you give anything short than the 1 month notice, you should understand that that means you've terminated in breach. And if the termination is done by breach, then you can't expect your employer to pay you anything you're entitled to, because we need to understand something. The law is also balanced. So if you're expected to do something and you did not do it, then you are not entitled to any advantage. So the first question I'm going to ask is whether the 2 weeks notice is sufficient. If the 2 weeks notice is sufficient, then you now proceed to ask yourself whether by giving the 2 weeks notice you are entitled to anything in the contract of employment. Now, let me quickly say this and address the fact that you said for other people that resigned, that they're being paid for 3 months. Now, that's very important. A contract of employment is personal. A contract of employment is not collective. That's why there is a clause for parties in a contract of employment. They will say this contract of employment between XYZ and between ABC. So for the fact that you don't know what is in the contract of other people that are being paid 3 months, so you cannot generalize it. It is personal to you. So if for any reason there is any clause, any entitlement clause in the contract, and you've met the condition to merit that particular entitlement being paid to you, then I think you have a strong case. But if there is nothing like that in your contract of employment, I'm afraid I think the company may be right by the principle of consensus ad idem. And again, you should also understand the fact that anything that is not in the contract cannot be imported into the contract. So the fact that they paid the other people 3 months doesn't mean that they will also pay you for that 3 months if that particular clause is not contained in the contract of employment. The contract of employment is usually interpreted literally, as stated in it. So for Leye from Ifo, you said that you were told that you'll be paid gratuity after 5 years. Now, the first question is, you were told, is it in writing? Is it contained in your contract? If it is contained in your contract, then it becomes a mandatory obligation to be performed by the employer. But if it is not contained in your contract, and if there is any other way you cannot reference it, then it may be very, very difficult. And I think I quickly need to clarify the difference between gratuity and pension. Now, the position is very clear. As far as since 2004 that the Pension Act, has been enacted, we have a new one now, which is the Pension Reform Act of 2014. Since 2004, every company, complies with the Pension Act. So the question I'm going to ask you is whether that provision of that gratuity is pre-2004 or post-2004. Because again, the Pension Act and even the Pension Reform Act even goes forward to say that if a company has been paying pension in-house, that's pre-2004, and after 2004, the company must revert to the position of the statute, that is paying the contribution to the necessary pension fund administrator. So you need to understand whether the gratuity that the company said they're going to pay to you is in writing. If it is not in writing, then your chances of getting it is very, very slim. And again, you said the company said that they're not going to pay gratuity because of pension contribution. If in the first instance the position of that gratuity is not even stated, then like I said, your chances is very low. But if it is contained in your contract of employment, and not only contained, the exact amount they said they're going to pay to you is stated, then I think it becomes a mandatory obligation on the part of the company. Everything is contractual, so you can claim it by enforcing the terms of the contract. You can go to court and tell and apply for another or specific performance for the company to do what is contained in the contract.
Mr. Ireoluwa Oguntunwase, like I told our listeners and here, as you can see, before now we have a long list of questions. So what I think I'm going to do is, and time is gone already, for those of us saying that we should extend the time, no problem. You know what to do. Contact our marketing department. You can call 0808-2500-745 for advert placements and the likes. Please, you can call Modinot on that line. Please, it's important. Now, this is what I think I would do, please. I would try and bring Mr. Oguntunwase here next week by the grace of God again to attend to our questions. But between now and then, please hope you don't mind me giving your number. People are asking for your number, and I think people have a lot of labor-related issues. Do you mind if I relay your number, please?
Very well, you can.
All right, please. Well. You can first get him on Instagram at Labor Clinic 9JA, Labor Clinic Niger. His numbers are 7. Did I say 7? I'm rushing. My producer, please now. My producer is on my neck telling us time. 0706 372 5524. 0706 372 5524. Alternatively, 0705 629 2571. 0705 629 2571. He has a lot of programs coming up, different times, different dates. Please hook him up on these lines and ask your further questions. We will try and bring him next week. It cost a lot to have him here today, please. So I need reimbursed first to bring him back next week to answer our questions. I'm sorry for questions I could not take, for calls we couldn't take. I have your questions, trust me, written down. I'm very, very sorry I couldn't take them. We will try next week we'll make the talk short next week so that you can have more questions to attend to. My name is, you'll be hearing the voice of Mr. Ireoluwa, in fact, barrister, it's not easy, it ain't easy, man. Barrister Ireoluwa Oguntunwase. When they get in the house too, he came together with him. His name is what, please?
Adewale Adesoya.
Mr. Adewale Adesoya. He has been smiling here since. I'm Kayode Aderemi. This is your program, The Law and You on Rockcity 101.9 FM. Like I always tell us, whatever thing you do between now and next week Sunday, ensure that you are on the right side of the law. Thank you, AK, our video man too. God bless you all. Thank you.